of North Dakota versus Mitchell Joseph Kohler, 02-2025 CR 118. Attorney Duffy appears on behalf of the state. Attorney Freeze appears by reliable electronic means. The defendant does not appear with the court's permission. Status of this case: Mr. Kohler entered guilty pleas to these counts. Court ordered a pre-sentence investigation report. Before the pre-sentence investigation was returned and before sentencing was set to occur on January 26, 2026, the state moved to dismiss all 5 charges, and the state's motion alleges Mr. Kohler has been federally indicted. The court got that motion.
A rare North Dakota courtroom appearance turns unusual fast when the judge admits the case is confusing. That's never a great sign.
This morning, and I quickly cranked out an order vacating the pre-sentence investigation risk assessment addendum order, and I exonerated bail, and at the same time I signed the state's proposed order dismissing the action. Thereafter, so I did those things this morning, and at a later time, after the court had already signed those 2 orders and filed those 2 orders, the court received Mr. Freeze's response in opposition to the motion to dismiss. Even though they are listed in Odyssey in a different order.
The defendant already pled guilty, but before sentencing, the state moves to dismiss all charges, an almost unheard of move.
So, to be clear, the motion to dismiss was given to me this morning. I drafted that order vacating order for PSI sometime before 9 a.m. when we started court, and at the same time I signed the order to dismiss. That order to dismiss was signed at 8:44 a.m. this morning. Mr. Freeze's response is in the record as record index 64, and it is listed before the order, but I didn't receive it until after my order had been issued. So I wanted to make clear that even though it precedes the order to dismiss in the record, it followed.
Instead of celebrating, the defense objects to the dismissal, arguing it would actually harm the defendant at this stage.
The order to dismiss in actual chronological time. After reading Mr. Freeze's response, I scheduled on my own motion a status conference on an emergency basis. And here is why. Ms. Duffy obviously didn't get a chance to respond to the brief, and I ruled on it probably before I should have. I should have given Mr. Freeze a reasonable opportunity to respond. Most times defendants don't oppose a motion to dismiss. This case procedurally, again, a plea has been entered, sentence has not yet occurred. The court will note that Mr. Freeze cited.
The judge signs the dismissal early, then realizes the defense objection was already filed. Timing becomes the first problem.
State v. Langang, which is a 2009 case, and State v. Welch, which is a 1984 case. Mr. Freeze didn't reference State v. Lee, which was just decided this year. My reading of State v. Lee, 2025 ND 148, indicates that under Rule 48, I don't have a lot of discretion in denying a motion to dismiss from the state. I don't know if that has a legal effect on State v. Langang, if it implicitly overrules Langang to the extent that a motion is brought in this procedural status, which is why I called this hearing. And I thank Mr. Freeze for sneaking me in before 1:30 when he has other matters on his calendar. But the issue, as I see it, is do I have any discretion under State v. Lee and Rule 48 to deny the motion to dismiss?
The defense argues Rule 48 doesn't apply after a guilty plea. According to them, dismissal is no longer legally available.
Or at least stay the decision on it. And frankly, I don't know the answer. So who wants to go first?
Your Honor, I can certainly go first if I may.
Go ahead.
And I would note for the court, your chronology differs than mine, Your Honor. Under Rule 3.2, Mr. Kohler has 14 days in which to respond to a motion if it's been properly filed with the court. I did receive the court's order exonerating bail, which indicated it was going to sign or going to grant a motion to dismiss. I promptly filed in response to that the objection that's before the court. Thereafter, I received, and the order of dismissal was documented. So even though the court may have received things in a different order, what was docketed and what was provided to the defendant was done in a different chronological order that the court had outlined. State versus Lee is a case in which there was a dismissal motion filed by the prosecution before a plea of guilty was entered. There is a jurisdictional issue here. The state did not contact me, did not advise me of an intent to dismiss the case, didn't seek the defendant's agreement to dismiss the case. And once the plea has been entered, the proper vehicle, the proper mechanism isn't a Rule 48 motion to dismiss. The only mechanism by which the case may be dismissed is a statutory mechanism where the court is granted explicit authority, like a deferred imposition of sentence or completion of probation early. Otherwise, the only mechanism, the only vehicle to properly do this under well-established case law is for the defendant to withdraw or file a motion to withdraw his plea of guilty and upon a showing of a fair and just reason at this procedural posture in the case. As indicated in my response, I'm simply in a position where I cannot advise Mr. Kohler as to what is his best option, but a dismissal at this point would be highly prejudicial to him due to the procedural posture and the fact that there is a possibility of dismissal of the federal indictment if this court sentence in the companion state case vindicates the federal government's interest. In light of that, I would simply ask that the court withdraw and set aside its earlier orders. If you wish to stay in this matter to give the defendant some additional time to evaluate his options, I have no objection to that. But this is a jurisdictional and procedural issue that's not right for the court to make a decision of this bill.
Stuffy.
In this case, Your Honor, I disagree with Mr. Freese's assessment that there's only one vehicle and one ability for a dismissal in this case, and that's through his client withdrawing his guilty pleas. I don't agree with that. Rule 48A talks about dismissal from the prosecuting attorney. It has a small amount of requirements, and that's that it be in writing, it concisely state the reasons for the motion. The state did both of those things. And then it says that the only time the state cannot dismiss a criminal case is during trial without the defendant's case. In this case, there's not a trial going on right now. These rules and the law is meant to be given the plain meaning of the words that are within the rule or the statute or thereof. And in this case, the plain reading shows that we don't have a trial going on right now. I don't disagree. He has entered a guilty plea. He's not been sentenced. And then related to Mr. Freese's allegations that he has no idea what the federal stuff is going on. My understanding from talking with the feds is that's not true. Mr. Freese is the one who is arranging his intake, I believe, into federal custody tomorrow. So saying that he has no idea what's happening on the federal side, I don't think that that's completely candid with the court or accurate.
I'm going to object at this point. Number one, this is inappropriate for her to call into question my integrity. I have not received a copy of the indictment. I've not received a copy of the discovery. I've coordinated a voluntary appearance for my client. That's all I've done. But for the prosecution to suggest that I'm being dishonest to the court is beyond reprehensible. I object.
Noted. Go ahead.
My understanding.
Told you. I told you. Disingenuous. It's interesting. I mean, he could be. I don't know. But again, I told you this case is weird. We got name calling. We got, I don't know, the first time I've ever seen a defense attorney object to a dismissal. It has to have something to do with it being federally indicted. I don't know. Let's just continue to watch. Maybe it'll be broken down for us.
Mr. Freeze, as he said, I'm not disagreeing that he is coordinating this. I'm saying that he has coordinated that. What they have disclosed to him, I don't know that either. I'm not necessarily calling into account his integrity. I'm just saying that what he is telling the court is not, I don't think, the entire picture. I understand he's coordinating his apprehension or whatever you want to refer to it as tomorrow. And if he shows up, I think that he will be apprehended that way. If he doesn't, I believe that they will do it themselves. But I guess I wasn't prepared for this hearing. I do think that the state has the ability to dismiss at any point in time outside of being in the middle of a trial if the state does not have the defendant's consent. In this case, we aren't in the middle of a trial. I don't think that you need a consent from the defendant. I think that it can be dismissed at any point in time, and that can happen at this point as well. Related to the charges on the federal side versus the charges on the state side, if the court recalls, we've had prior hearings on this where the state had stated that there is more information that's forthcoming from the investigation. That information, at that point in time, Mr. Freeze stated to the court that he didn't want this continued and he was fine with his client, in essence, being charged additionally in a different case based on the state's request to continue a case, or this case, and extend it a period of time so that the investigation could be completed. Mr. Freeze had stated to the court that he was fine with him being charged in a separate action. As far as when it comes to the same charges in the state court versus federal court, to my knowledge, they are not the same charges. I don't know if he has been charged with the exact same 5 counts that the state charged him with. I do know that on the federal side, there, I believe, is the charges that include the local victims. So I don't know how many exact charges there are, but they are not the same charges in state court versus federal. There could be duplicative charges if they had charged the same 5 videos that the state charged, but I don't think that they are the exact same. In fact, I know they are not the exact same because they incorporate the local victims that the state had attempted to have incorporated into the state's case by a continuance, in which Mr. Freeze objected and said he didn't want it continued. So if the court wants this in writing, that's fine with me. I would appreciate a little bit of time to respond in writing as well, as I wasn't prepared to come in and have a motion hearing today. But I think that the state has the ability to prosecute or to dismiss a case under Rule 48A. And I think that State v. Lee also incorporates the same approach.
All right, so here's what I'm going to do for today's purposes only. Mr. Freeze is correct that under Rule 3.2, and I should note that this motion wasn't brought as a 3.2 motion. It was just simply filed, presumably just under the criminal rules, under Rule 49 and Rule 48, to dismiss. There was no notice of motion filed under Rule 3.2. Nevertheless, the court probably acted prematurely. And so what I will do is I will vacate my order vacating order for PSI, risk assessment, addendum, and order exonerating bail. So I'm going to withdraw Record Index 62. I will withdraw and vacate the previously signed order to dismiss Record Index 66. I will give Mr. Freeze 14 days to file a brief. If he wants to file a supplemental brief, I'll give you some time, Mr. Freeze, to file a supplemental brief. If you wish, I'll give you 14 days to file that brief. That brief, I want briefing on the State v. Lee issue because as I read it, I don't think I have discretion. So I want State v. Lee briefed by both parties. I will give Ms. Duffy 7 days thereafter from receiving service of your supplemental brief, if you intend to file one, to file a response. You can file a reply brief if you wish. I'll give you 7 days to do that. So I won't touch this for another 28 days.